State of Nevada versus Zaon Collins, 20 CR 041639. Good morning, Mr. Schonfeld. Good morning, Mr. Collins.
Good morning, Your Honor. Your Honor, for the record, before you begin, I'd like to make note of the fact that the victim's widow is present.
Okay, thank you. Mr. Schonfeld, this is your motion. I'll hear from you first.
Thank you. Your Honor, as the court is aware, Mr. Collins was released on high-level electronic monitoring as well as other conditions, the scan monitoring, no driver's license, no driving. He has been on those conditions for 9 months at this point in time. He has done everything required of him, shows up in court even when his presence could be waived. He's obviously treating this matter with a great deal of responsibility. The circumstances since the time of the release conditions being imposed have changed insofar as the state took the case to the grand jury. The grand jury issued a no bill on the DUI. The court is well aware that the alleged substance in his system was at 3 nanograms per milliliter, which under the law as it existed at the time was barely over the limit. The law has since then changed as it relates to misdemeanors, and I know that we have dispute or debate as to whether or not that would apply to this case. However, the point being is that the Nevada legislature has taken into consideration that a 3 nanogram per milliliter level doesn't necessarily mean that the person was in fact impaired. So I think given the change in circumstances and the demonstration by Mr. Collins that he has been abiding by the conditions and is treating this responsibly warrants a either removal of the electronic monitoring or at a minimum placing on low level. The basis for the request, Your Honor, is that being on high-level electronic monitoring, Mr. Collins is allowed to leave his home only during the week. He is not allowed to pursue his athletics on the weekends. He's only allowed to have one person drive him. He's going to school, so his mother has to drive him. He can't take public transportation. He can't get a ride with a friend. He can't take Uber, things of that nature, because the officers that control the high-level electronic monitoring only allow for one person to drive him. So as a result, his mother, who is present in court, is the one who drives him. So if she has clients at 7 in the morning, she would have to leave to pick him up to take him to school, and then she goes back to work. So it's being a hardship on her as well. But the reality is that it's making it difficult for Mr. Collins to effectively pursue both scholastics and his athletics. As the court is aware, athletics isn't really a social or pastime. It's actually a potential career for Mr. Collins. And as a result of that, Your Honor, we are requesting that the high-level monitoring be removed or reduced so that he can pursue both his scholastics and his athletics.
Mr. Bauman, I'd like to hear you state.
Your Honor, as you know, it's the state's position and the court agreed at the time of defendant's initial release that the conditions under which he was released were just and necessary in light of the nature of the serious charges defendant faces and the potential extensive prison time that he's exposed to. It's also the state's position that, as the court is well aware, we've had argument before this court over whether the circumstances have changed for purposes of this court. And this court found in agreement with the state that the defendant remains at this time charged with both felony DUI and reckless driving before this court. And as he was at the time of his initial release, and the state intends to proceed to preliminary hearing before this court on both charges. Unless and until a higher court rules otherwise, the court's rulings on those matters remain the law of the case before this court. The state's position that circumstances have not materially changed since the time of its initial release, and I would ask that the release conditions remain in place.
Mr. Schonfeld, has the district court set a hearing date on my ruling?
November 4th, Your Honor.
That's correct.
Okay, so many of the facts that you have just now brought before this court again with regard to release of Mr. Collins are still pending before the district court. So whether or not the grand jury, with regard to the grand jury issues, whether or not this court has any jurisdiction, whether or not the state was proper in their filing of these matters, I'm not going to discuss or rule on those again because I've already ruled on those once, and my ruling has been writted up to the district court. So as we discussed the last time we were before this court, when you asked me about a bail motion, you thought that bail should still be remaining with this court, but until the district court makes their decision on whether or not the state has charged these matters properly. I am not going to touch that, but with regard to bail, you know, I do not see that there's been a change of circumstances at all. I mean, Mr. Collins, I want you to know that I appreciate the fact that you have abided by all of the terms of your release. You know, that certainly goes in your favor. The fact that I have just have seen negative drug results, I applaud you for that. I mean, you definitely are doing what you're supposed to be doing. However, again, the charges before the court are very serious. And I think you know that. And I think that you realize that now to some extent. And you are potentially, as we have also discussed prior, potentially, if found guilty, you know, looking at an extended prison sentence in this matter. I think it's great that you're going to school and that you're continuing your education as a young person. You know, your future before you is what you have to rely on. I know that you are a very accomplished athlete. You know, I've seen you play. I know what your talent level is. But, you know, that is one of those things that when you make choices in life, sometimes those other things have to be put on the sideline for a little bit. And at this point, this court still believes that, you know, the state has shown by clear and convincing evidence that they have a likelihood of success of winning at a preliminary hearing, that, you know, you are exhibited a reckless behavior, that you exhibited that you're a danger to the community. And I also have to weigh all those factors. I have to weigh community safety, you know, with release conditions. And at this point, I am not inclined to change from high-level electronic monitoring to low-level. I mean, it is a burden to your mom, I'm sure, to take you everywhere. But she at least gets to have you home, as opposed to other people that don't ever get to come home again, right? So my ruling stands at this point. We'll see what the district court, what their decision is on that hearing on November 4th. And at that time, we'll see what their ruling is. And, you know, then Mr. Schonfeld will make appropriate rulings and motions at that time. Okay? But right now, my word stands.
Your Honor, we need another status date after the November.
Yeah, so do you know?
I would anticipate that the court will probably issue a written ruling after the arguments. We probably need at least a week to 10 days
Okay.
after.
All right.
But
That's fine,
So,
mid-November.
do you want to go, Mr. Schonfeld, like mid-November? Do you want to?
Yeah, that's fine.
Okay, do you want to do the, like the 17th, or do you want to do the week of Thanksgiving? I mean,
17th should be fine.
17th is
okay,
good.
so let's go November 17th then at 7:30. Or November 18th, does it matter what day of the week it's on, Mr. Bauman? Would you rather Wednesday or Thursday, does it matter?
It doesn't matter.
Whatever date's better with our calendar.
November 18 at 7:30.
Okay, thank you.
Thank you.